Mr. Weiss.
Yes, Your Honor. This matter has been adjourned a couple of times. The balance owing is basically stemming from pet fees and a pet deposit for an animal that Ms. Bell had.
We dive straight into a stormy legal showdown. Judge Simpson is on the bench, and the stakes revolve around something that might sound trivial at first: pet fees and an emotional support animal. But don't underestimate this. Emotional support animals, or ESAs, sit in a legal gray zone that landlords and tenants clash over constantly. Right here we've got Miss Bell, who once had a pit bull approved as her ESA back in 2019, with proper doctor certification. No pet fee, no deposit, everything looked solid. Fast forward, the dog allegedly bites a tenant, gets removed, and she later replaces it with a chihuahua. Seems straightforward, not even close. Now the landlord wants recertification of her need for an ESA. That might sound routine, but legally it's a hornet's nest. Is the landlord allowed to demand new proof years later? Judge Simpson clearly smells something inconsistent. Viewers lock in. This case is about to unravel years of housing rights and expose serious contradictions in landlord policy.
The question that's presented is the application of ESA. Back in 2019, Ms. Bell applied for an ESA for a dog. I believe it was a pit bull. She had a letter from her doctor indicating the need for the support animal, and it was granted. At that point in time, she did not pay a pet fee or a pet deposit. Subsequently, I believe in February of 2023, she had to remove the support animal because it was a pit bull and apparently had bitten one of the tenants. That was in February. She replaced the animal, and then in October of 23, we requested that she certify the new animal, which I believe is Pride Chihuahua. And
Well, let me ask this, because I remember the issue, but the certification for the animal, however one wants to put that. Well, let me put it this way. Does the complex certify the animal?
the complex asked that she read certification that of her needs for the support animal, which in 2019 she did provide for us. We asked starting in October when she got the new animal, we asked that she recertify herself that she had a continuous need for that support animal.
Okay, and again, that I guess brings me to the next point. If nothing had happened with the pit bull, she wouldn't have had to recertify anything.
Judge Simpson zeroes in on the heart of the issue. The only reason this whole fight exists is because the pit bull was removed. If that dog had stayed, no one would have demanded new paperwork. This is powerful because it exposes selective enforcement. In law, consistency matters. If landlords treat one tenant differently from another, or even treat the same tenant differently at different times without clear rules, it opens the door to claims of discrimination. Fair housing laws were designed to prevent landlords from moving the goalposts mid-game. Ask yourself, should a person's need for an ESA suddenly expire just because the specific animal changed? Imagine needing glasses. Your prescription doesn't vanish if you swap out frames. Judge Simpson is pressing Weiss to explain why the timing makes sense, but you can hear the cracks forming.
Well, we take the position that we could have asked her to certify, but we didn't. The fact that she had the replacement animal brought it to our attention. Does Ms. Bell still need a support animal? If so, we ask that she be recertified. We asked, and I have if I can present to the court, if I may approach Your Honor.
What are those? And
This is a thread of emails between Group 5, Group 5's attorneys who was handling the case then, and Nikki Green from Fair Housing, talking about the pet situation. And Nikki Green basically said she was going to follow up with her doctor, I think Dr. McAvoy, to see if we can get the certification. According to our information, Dr. McAvoy refused to do the certification. We asked that.
Here's where things turn messy. The landlord's attorney admits they contacted multiple doctors to recertify Miss Bell's need for an ESA, but one doctor outright refused. That's huge. Why? Because courts don't like fishing expeditions. When a landlord starts digging into someone's medical need without clear authority, it looks invasive, possibly even discriminatory. Judge Simpson pounces on this, pointing out that the certification in 2019 was about Bell's need, not about a particular dog. That's a critical legal distinction. Emotional support animals aren't like driver's licenses that expire. Once your need is certified, it's usually presumed ongoing unless challenged with strong evidence. So why chase new documents years later? From the outside, it sounds like the landlord was hoping to catch Bell in non-compliance. But that kind of gotcha approach rarely sits well in court.
She possibly
but was that the
doctor.
previous doctor? Okay, but here's my issue with this. When she did that in 2019, she's not certifying the animal.
Correct. She's certifying her need for an animal.
Right. So what would lead the complex to think that changed?
Well,
Because and the reason I'm asking that is because based upon at least what's been represented to the court, the only thing that happened is the removal of the animal.
that brought it to the attention of management that does she still need a support animal? And that's why we requested certification.
Why would that raise the issue?
Well, I believe there's a difference between an ESA and a service dog. A service dog, if you're blind or
Right.
handicapped, you apply for a service dog. That's a different type of certification. And at that point in time, if it's granted, basically it's for life. Support animal is different.
The attorney tries to draw a line between service animals and emotional support animals. And yes, legally there is a difference. Service dogs are highly trained, task-specific, and protected under the ADA for life. Emotional support animals, by contrast, don't need training and are covered under fair housing rules, not the ADA. But here's the flaw. Nothing in fair housing law says a tenant's emotional needs have an expiration date. Judge Simpson hears Weiss, implying ESAs are somehow temporary by default. But when pressed, Weiss can't cite any statute. This is where sharp legal minds know, if the law doesn't explicitly give landlords that power, courts are unlikely to invent it. You can sense the judge's frustration building. It's almost as if Weiss is trying to stretch the law past its breaking point. That's always risky in a courtroom with a judge like Simpson.
It's like,
Well, what explains to the tenant that it's different? I mean, because you from what I'm hearing, and correct me if I'm wrong, in 2019 to 2020, in 2020, the dog is still there and she doesn't have to do anything. The dog just continues there. 2020 to 21, same thing. 2021 to 2022, same thing. So I'm looking at a 3-year period where she has to do nothing. She has this dog.
We didn't
Then
raise
the-
that issue at that point in time, but
Why, though? I mean, what makes not raising the issue at that time as opposed to raising it later on? What's the distinction
well,
if you're not certifying the animal?
I believe that in a situation that the complex has the right, and there's nothing in the law either way, that we have the right to certify, recertify, or we don't have the right to recertify. So it brought us to the attention, does Miss Bell still need certification? And it's a simple process. All she had to do is go to the doctor.
But I get that that's the process that the landlord wants her to enter into.
Correct.
The problem that I'm having with this is why was the request made at that time as opposed to being made at every 6 months, every year, every whatever?
Well, the dog was, the pit bull was removed in February of 23. We waited 8 months. She got a new dog. We waited 8 months until October of 23 in order to give her some time to get the certification. At that point in time, we formally requested it, and that's when we started
Okay, but when
assessing.
did the new dog come in?
Notice the timeline problem. The pit bull leaves in early 2022. The Chihuahua arrives December 2022, but the landlord doesn't ask for new certification until October 2023. Almost a full year later. That gap is deadly for their argument. If they truly believed recertification was urgent, why wait? Courts often apply a reasonableness standard. Was the landlord's action timely, consistent, and fair? Here it feels arbitrary. Judge Simpson points this out. Why demand proof so late if the issue was supposedly so important? This inconsistency undercuts the landlord's credibility. For viewers, it's a reminder in legal disputes. Timing is everything. Waiting too long can make your claim look like an afterthought or retaliation rather than a legitimate concern. Audience poll: should landlords have the right to periodically recertify ESA needs, or does that cross the line into harassment?
Excuse me.
When was the new dog?
I can tell you all of that real quick because my mother doesn't even really sure of it. Faithful was moved out of the house in April of 22, not 23.
Okay,
She got
that's
home
fine.
in December of 22. You all got the wrong dates. I don't know
He
why.
doesn't, ma'am, I don't need that.
Okay.
If the dog got removed February, April,
Mhm.
when did the new dog show up?
December of 22. December of 22.
Yeah, it was 8 months after the old dog was removed.
And then when was the request made for the new?
In October of 23,
So,
I believe.
so was that the first request for the
For
ES?
recertification, yes. In October of 23.
So why did that happen then?
Why? Because at that point in time, we reviewed our records and we said, well, does Miss Bell still need the dog? And
So-
that's when we,
Whoa,
that's,
whoa. No. I'm just trying to sort this out. Because this doesn't make much sense to me. The pit bull gets removed February of April, whichever it is, of 2022. Right? The new animal comes in December of 2022. Right? And the request for this is effectively a year later, 10 months later,
correct.
by the landlord.
Yeah. Yeah, I understand what this court is struggling with, but if you take a look at, comparable laws like workers' comp, not social security or disability insurance, they have the right to review the continuing disability.
Weiss tries to rescue his case by comparing ESA recertification to disability reviews in Social Security or workers' comp, but Judge Simpson cuts through this analogy like a knife. Why? Because those programs are backed by clear statutes. Federal law explicitly authorizes periodic reviews for disability benefits. Landlords don't have that authority written anywhere. Not in leases, not in fair housing rules, not in ESA guidelines. Without a legal foundation, the analogy collapses. It's like comparing apples to court filings. It just doesn't hold up. Simpson's point is simple. Unless the lease specifically gives the landlord that right, they can't just invent it later. This exchange highlights a recurring theme in law. Landlords love to borrow concepts from other systems, but unless the legislature says so, courts won't enforce them.
Every so often, every 6 months.
But you're not reviewing her disability.
Yeah, by asking her for recertification, we're asking.
Where in the lease does it state you could do that? I mean, because
it doesn't.
That's the problem. The problem
we're dealing also with the law, Your Honor. The law is unclear on it itself. The fair housing, as it pertains to ESA, and I checked into it. There's
okay. I get that. I understand the complexities or absence thereof. What I'm looking at the circumstances of this. So one thing that's very clear to me is, had the pit bull remained, there wouldn't have been a request.
Maybe.
Well, there wasn't.
There wasn't.
Right?
Yeah. But
pit bull gets removed, a new dog comes in, and when the new dog's there still is no request.
At that point in time, no.
Then 10 months later, effectively, almost 11, really, I guess, depending on when in the month these things are occurring, 10 to 11 months later, there then is a request.
Correct.
And I'm trying to figure out, why was that request made?
It was brought to our attention that, does Miss Bell still need a support animal?
Brought to your attention by whom?
It was brought to our attention in the review of the record. A review of the record when we found out that she had the new dog, we asked that she recertify herself as a need for that support animal. And it's a simple, I understand the court, but it's a simple process. And according to
But why would you ask? That's my question. I'm not so much concerned about what the process is. I'm not concerned about what happened, didn't happen. Why would you ask?
It was a review of the records showing that she has a support animal. Does she need a support animal?
But hold on a second. When was the landlord aware of the new animal?
This is classic courtroom cross-examination, but delivered by the judge himself. Simpson drills down to the essential timeline. When exactly did the landlord know about the Chihuahua? The reason is simple. If you want to enforce a rule, you'd better prove you were aware of the issue at the right time. The attorney wavers, pointing to 2023 emails. But notice how weak that sounds compared to the concrete dates Bell's side provided. Courts look at credibility. Tenants who provide clear dates often come off more reliable than landlords who rely on vague records reviews. For viewers, here's the big takeaway. If a landlord delays action for months, it undermines their authority later. It's like finding a problem with rent in January, saying nothing until October, then claiming it was urgent. Judges don't buy that.
This is Kurt Herbeck. He's the.
When was, I just need an answer.
October.
October of what?
October 23. Asked when she was first charged, FB.
No, I'm not saying a charge. When does the landlord know she has this new animal?
I think it was sometime in 2023, according to the email threads I'm looking at. It was prior to,
It was several months after she removed the pit bull. She was observed with the Chihuahua, and that's when she was asked about it. She never came to the.
That was 11 months after.
yeah, but we didn't know that she had the Chihuahua at that point in time.
Is there a policy regarding this at all with the landlord?
Is there a policy
A
with
written policy? What places the tenant on notice that this has to happen?
This is a devastating question from Simpson. Is there a policy? In law, policies are the backbone of enforcement. Without a written rule, actions appear arbitrary. Here, the Landlord's Council admits there's no reference to ESAs in the pet agreements, and nothing in fair housing requires periodic recertification. That admission guts their argument. Why? Because courts hate uncertainty. If tenants aren't placed on notice about a requirement, it's unfair to suddenly spring it on them years later. Imagine if the DMV demanded a random new driving test 5 years after issuing your license, without any rules stating they could. Chaos. Simpson is pressing for one thing: structure, and the absence of it is damning. For viewers, this demonstrates a key principle: rules must be predictable. Without policy, landlords risk accusations of discrimination or selective enforcement.
We
Or
notify
can-
them.
Or you can't do that, Mr. Weiss. She's under lease.
I understand. The pet agreement. I don't know. Pet agreement. There's nothing in the pet agreement that references it, but it also doesn't reference ESAs in the pet agreement. So ESA is a part of the fair housing.
Right.
Okay. There's nothing in the fair housing. I understand.
I'm trying to figure out what triggers the landlord to ask. And with that, what places the tenant on notice that the landlord can ask and then needs to comply with something?
Well, they have to inform us that they have a pet. Okay. If they're claiming that they have a need to have that pet classified as an ESA, emotional support animal, they have to go through the procedures as set forth.
Okay, but that's apples and oranges.
No, I don't think so.
Well, it is, because she's not here because she failed to notify you of the dog.
No, she's here because
She's here, at least what the landlord's saying, is because the landlord made a request for the doctor to indicate that she needed an ESA.
the continued need.
And what gives the landlord the right to ask her that once she has already given it? Under what authority is the landlord requesting that?
Well, as I said, the ESA has no law either way. As far as
Either way,
required,
in terms of what?
Weiss admits something damning. The law is unclear. In courts, uncertainty is not a weapon, it's a weakness. If you can't point to a statute or rule, you're asking the judge to invent one. Judges rarely do that, especially in housing cases with Fair Housing Act implications. Simpson immediately seizes on this gap. Without clear authority, the landlord's actions look arbitrary. This is where the case tilts dramatically in Bell's favor. Think about it. Fair housing laws exist to prevent housing discrimination. If courts allowed landlords to demand random medical recertifications, tenants could be harassed endlessly. That's why unclear law actually strengthens the tenant's shield. Viewers, this is a great example of how silence in the law can work both ways. Here it protects Bell because courts lean toward tenant protections when ambiguity exists.
Of requiring recertification or not.
Here's the landlord's problem.
I know what the landlord's
Yeah.
problem is.
If the landlord said, okay, every year, for those that have an ESA, every year.
What follows next is the part investigators still talk about, the moment where motive, method, and mindset collide.